Hey everybody, I hope you are well. I am sitting in the shade of my car, enjoying a nice breeze. A little cooler today and yesterday at least than it was last weekend. Last weekend there were so many events locally that I don't think I got out of my car for all of 2 days, although I carried several changes of clothes because the events were very different, but also because it was hot out there and I needed to dry off occasionally. The events included two wonderful and exuberant Pride events, one on the Washington Green on Saturday and one at the Edward and Sharon on Sunday. Breakfast on the Farm, which is a great opportunity both to catch up with FFA students, ag ed teachers, and the Farm Bureau on some legislation that we've been working on together. So good, both personal and policy-wise. And also other events in the community, some of which were sadder than others, as we lost a beloved young member of our community recently. And there were many, and will be, I hope, many opportunities to help that family through what they're experiencing. And then tomorrow, switching back to, we will be in special session, just for the day. The Senate is in fact in today considering the bill, which is a variety of things. Some of which were in that final finance bill that we were trying to get over the line that fixed a few things that passed in the House, but not in the Senate. So a couple of those will be part of what we consider tomorrow. The first impetus for us going in was a bill to fix we've had several pieces of legislation on the car tax, which is very understandably unpopular both amongst constituents and amongst legislators, but it's a source of revenue that towns are now dependent upon, so it's hard to change. But some of the legislation with respect to valuations of cars might have had an unintended consequences of raising rates on commercial property, commercial vehicles. And so we're going in to fix that to make sure that doesn't happen. And then there are a number of other fixes, again, some of which were in our finance bill, some of which were in other committees, a lot of which have a focus on helping businesses. There's one that we had that makes the regulation of the insurance industry more fair and equitable. Another that helps it's sort of a certain kind of innovative financial institution come to Connecticut and thrive, and it helps employers who may have been who used employee retention tax credits during the pandemic. Just make sure that they're not those are dealt fairly as the law changes. Some of them got hit by an unexpected change in the federal law, so we're trying to help buffer that effect. So a lot of little things like that. I'll add more details in the newsletter about what we'll actually talk about tomorrow. But then I wanted to actually just talk briefly about the Supreme Court. As many of you know, I was a federal prosecutor in federal court pretty much every day, writing for it, if not appearing in front of it. And so, like many of you, I follow the Supreme Court avidly, but it also has a real impact on Connecticut. And so I thought, given a couple of headlines recently, it would be worth talking about. First of all, of course, earlier this week was the 2-year anniversary of the Supreme Court overturning Roe versus Wade, a 50-year-old precedent. That was a real, balancing act of rights and ensuring that the rights of pregnant women that they had rights, and the state couldn't just override a woman's ability to make those choices for herself. And of course, that decision was overruled, and that in Dobbs, and we are now seeing the after effects. So the authors of the Dobbs opinion, part of it, focused on the fact that we're returning this to the state, we're getting the Supreme Court out of this, and so we don't have anything to do with that. And so the immediate effect in Connecticut, of course, that Connecticut had codified Roe, so it is state law. So the fact that we lost the constitutional protection didn't mean that women in Connecticut lost that access to reproductive care. However, it did, because it's no longer constitutionally protected. It's now just state law. That's, easier to change, needs a little bit more protection. Also vulnerable to, should Congress enact a national ban, then all of our work is gone. Also, of course, the fiction that it was taking it out of the Supreme Court is clear even this year with two big abortion-related cases in the Supreme Court. One that's been decided on mifepristone, and one that still remains undecided on a federal law known as EMTALA, which I'll talk about in a second. So the mifepristone case, of course, it protected access to abortion drugs, which make up the majority of abortions in this country. But it was understand that was a ruling, it was a standing, so this is a technical legal ruling. And the fact that that case was decided against the standing of the plaintiffs who are trying to remove access to mifepristone really is just important to remember that was the Supreme Court really just acknowledging a facially preposterous theory of standing, as anyone who's ever appeared in court over many years could tell you. So that, when and if plaintiffs who have an actual injury wind up in the Supreme Court, I think we are facing a different set of risks. So a ruling that protected access for the moment, but stay tuned. Of course, yes, then there's the EMTALA case, and that basically, highly technical case, but basically has to do with a federal law that would require that if somebody needs an emergency abortion, that she would have access to that regardless of the fact of whether a particular state has banned abortion. So that's, in other words, that taking care of someone who is in mortal danger with a necessary abortion, whether doctors in that state would be permitted to perform that. That case is still in front of the Supreme Court. Then there are other issues. There will be issues on interstate travel that will likely come before the Supreme Court. IVF, many headlines about that. So I think we're not done with the Supreme Court paying attention to that, and stay tuned. Another big area are a series of gun-related cases that also could have an impact on Connecticut. The most recent one that was decided, I guess actually there have been two decided recently, one of which was the bump stock case, Garland versus Cargill, and that was not a constitutional case. That's a statutory interpretation administrative law case. So it does not affect the fact that Connecticut also bans bump stocks. Those bans remain in place. But some of the reasoning behind in that case, makes one wonder that if someone challenges the bump stock ban on constitutional grounds, we may have that would threaten Connecticut's legislation and be worrisome. The other gun case that was decided most recently, Rahimi, which is the basically allowed the existing law that was challenged allowed a domestic abuser who had been found by a court to be dangerous, whether you could remove that person's weapons. And the Supreme Court upheld that law. Many of us were fearful because the earlier Supreme Court ruling known as Bruin, which established this new history and tradition test, it had the Bruin case, very narrow interpretation of what an analogous sort of historical traditional gun regulation would be. Very broad interpretation of what an arm means, notwithstanding the fact that the arms in existence at the founding were quite different than the ones in question today. But the court did allow those laws, which could disarm domestic, those who have been found to be a risk to their domestic partners. You could disarm them. So stepping back from the brink on their ruling, but it does cause a lot of concern about that interpretation because although the ruling was nominally 8-1, there were, I think, maybe 6 different opinions written on that one. You could, instead of 8-1, you could call it a 2-2-1-1-1-1 case. So a lot of question about what that means for the future and how the Supreme Court is going to look at, any of Connecticut's regulations. So we will fight heartily for those. Of course, there are other cases that the Supreme Court left immunity, January 6th, homelessness, administrative law, air pollution, all of which may or may not affect Connecticut. So we'll keep our ears tuned. It's hard to talk about this verbally. Some of this is highly complicated and technical. And then there was one recent case that has the direct impact on Connecticut, and it's not so much a written decision as it was a decision by the Supreme Court not to pick up a case. So the Supreme Court declined to take a challenge to Connecticut's vaccination law. So a couple years ago, Connecticut removed the religious exemption for school vaccinations. We still allow a medical exemption. In fact, we broadened it a little bit so that it was more accessible. But we removed the religious exemption because there wasn't really a grounding for that. It was challenged in court at the lower court level, upheld by the Second Circuit, and then most recently the Supreme Court declined to take it up, meaning they were leaving the decision in place that upheld that law, which means that Connecticut's laws on vaccination for children, which keep children from getting preventable illnesses that we are seeing break out in other parts of the country, that remains on the books. So lots of complicated things that we're dealing with. Lots of more fun local events when I'm back. So hope you have a great weekend and see you soon.